So talking about strategy, is there a time as a defense attorney that you're actually going for a mistrial? Is that something that you actually like say, let's go for a mistrial?
That's always a potential strategy, and that's used a lot more in the civilian world. And so mistrials happen. That you can have a mistrial in the military where there's, not having a mistrial would be a manifest injustice is the word, right? I've only seen a potential mistrial happen once in my entire career. So they're really rare, because what will happen is if there's all these issues in these cases where a prosecutor just does something blatantly wrong, a military judge will almost always try to cure that with instructions. By instructions, it says, I'm going to give the jury or the panel, I'm going to read them an instruction for them to totally disregard this piece of evidence. And then they'll poll the members and say, will each member or each jury member agree to follow my instructions and disregard A, B, C, or D, or E? And so in the military, we're all used to following orders and required to follow orders. And so you're going to have an 06 military judge and an 05 panel members, or maybe have an 06 panel member, but that becomes a lawful order that they're required to follow. And so typically mistrials don't happen very often because you have these curative instructions that are given. Now, that being said, if there's a mistrial, it's usually because of prosecutorial misconduct, not on the defense side, right? I'm never going to do something that's going to try to have a mistrial or interject, not on my side. But if the prosecutor's screwing things up that bad, then you can always require. I've made a couple requests for a mistrial. They're very hard to have granted. I have had a mistrial granted before. But what happened? We went and tried the case again. So it goes back to strategy. You have to look at it and say, let's say you're ahead of the game. Let's say it's the fourth quarter, so to speak, and you're up 20 points, and they're screwing everything up. Well, you don't want a mistrial, because then you're going to have a new trial, and you may not be up, a lot of points in the fourth quarter. And then you said, let's just close this game out and win. And so there's a strategy that's involved there. So while as a defense attorney, I never try to create a mistrial. I think there's some ethical problems with that as well, to try to create a mistrial. But if the prosecutor is really doing something wrong, if the judge is really doing something wrong where you can't ring a proverbial unring the bell, then yeah, we can request a mistrial or make a motion for a mistrial, but it's very rarely granted.
So it's not a strategy that you aim to try to get to a mistrial. It's something you're going to point out and ask for.
So I'm going to do everything I can so we don't have a mistrial. But if we've gone that far astray, where I say, yeah, this has gotten really bad, then we'll ask for a mistrial and we'll litigate the issue. Has
it ever happened?
I've had it happen one time. I had a trial counsel in Korea comment on multiple times about our client's right to remain silent, and basically said if he was so innocent, he would have testified. And then the judge almost lost their mind over it, and then it happened again. And we made the motion for a mistrial because it was just that bad.
Have you ever had a few good men moment, like a Colonel Jessup moment, where you're really trying to get somebody? Have you had something like that?
Yeah, maybe not the Colonel Jessup. I've done it with a CID agent once. I mean, I knew a CID agent had planted some evidence. I knew that. I mean, you don't like, oh my God, a CID agent planted evidence at a crime scene. Like, that actually happened. I mean, it's not just accusing someone of planting evidence. We had evidence that they planted evidence based on the way it was crazy. Based on the way the photographs were taken, we took the metadata on the photographs of a crime scene, and all of a sudden this evidence appeared that wasn't there before. And once we got copies of pictures that were deleted, it was apparent that evidence was planted. I just couldn't believe it. Like,
was it brought out in court, or did you?
Oh, it was brought out. I saved it. No, I saved that round, right? I just saved that round. And the agent testified, and I started slow rolling him a little bit. It was like just kind of crank it up to a boil. And I started showing him this picture. And I'm going to show you Defense Exhibit 21 Defense Exhibit Alpha for identification, Defense Exhibit Bravo. Why don't you go ahead and take a look at the metadata for me? Have you had a chance to look at the metadata? I have. Go ahead and tell me when that photograph was taken, and go ahead and describe what was in that photograph. Show him another picture, another picture, another picture. And then all of a sudden we go back in time, and it's like, okay, there was a blanket that was there, and the blanket had some DNA on it, and they wanted it in a certain room. And the blanket wasn't there before in the establishing shots, and it wasn't there after, and the establishing shots had been deleted. And I was like, well, Special Agent, I said, Special Agent, I'm looking at him, and the jury kind of gets it at this point in time.
He's probably getting it too. He's probably getting it.
Oh, he's getting it. And the judge is going to take his glasses, leaning down, waiting on it. And I've got like a whiteboard, and I'm kind of drawing stuff out, right? Kind of just in court. And it would happen. I'd show it. Just I'm trying to demonstrate, trying to be a little bit over the top with it. And so I said, hey, Special Agent, are you seeing what I'm seeing here? Do you see what I'm seeing? And I'm just smiling a little bit. And I try to calm it down. And he looks at me. Yes, sir. I said, you planted the evidence. And the government's objection. It was objection. It was like, the witness has rights. You know what I mean? It wasn't that crazy, right? But he had to either invoke his rights or incriminate himself there.
Did that end up in a criminal accusation against that guy?
Of course not. It should have. Now he got kicked out of. It didn't go criminal. It went administrative, and he actually was removed from SCEDI, so that caused him to be removed, right? But that being said, it wasn't a criminal case, and they had planted evidence, for God's sakes. And the jury acquitted almost immediately. I mean, it was an easy acquittal. It was a full acquittal. But had we not, but think about this. In order to be a digital forensic examiner, we had to have metadata. We had to do a lot of work to get there. And this is someone that would probably still be in prison right now had that not been done. And so it goes back to, is it worth hiring a civilian attorney? Well, in that case, it sure as hell was.